blow the whistle with EJLee Law.
Yo, whistleblowers, what's up? I'm throwing flags on the place. I'm protecting your stuff. Hey, whistleblowers, and welcome back to another episode of Blow the Whistle with EJLee Law. So we are talking about technical foul number 5. What is technical foul number 5? Brand due diligence. But before we get started, let's get a little bit into who is EJLee and EJLee Law Practice LLC. EJLee Law Practice LLC is located in Metro Atlanta. We handle copyright and trademark registrations worldwide, adding patents soon, as well as drafting, reviewing, and negotiating contracts for members of the entertainment industry and Georgia businesses big and small. So we always start off over here with a technical file recap of the 4 technical files that we've covered, and then we'll go straight into technical file number 5. Technical file number 1, what is the purpose of a trademark? Technical file number 2, understanding the IP differences. Technical file number 3, understanding the purpose of a slogan or catchphrase. Technical file number 4, a design mark versus a word mark when you're getting ready to file your application. Do you need both, or do you need to focus on one or the other? And now, technical file number 5, brand due diligence. Brand due diligence is the responsibility to thoroughly research a brand name, a logo, sound to ensure your use of that mark is unique for your industry and does not infringe any third-party intellectual property rights, whether direct or indirect. Considerations. Strict liability. Strict liability is a standard of liability under which a person is legally responsible for the consequences flowing from an activity, even in the absence of fault or criminal intent on the part of the defendant. The reason why I wanted to make sure that I brought this up is because as we're talking about a recent case that came up out of California, an influencer was not allowed to dismiss herself from a lawsuit for trademark infringement simply because she promoted a brand that is being accused of trademark infringement. And that's pretty interesting because the influencer had nothing to do with putting this brand together, including the name that was chosen. All she did was promote the brand via a blog post talking about the product. So that's pretty interesting. We're going to be discussing that in the IP Streets discussion in technical file number 6. This particular technical file number 5, the IP Streets section or segment was recorded prior to. So we're going to be talking about that case in particular in technical file number 6. So I want you guys to really be on the lookout for that, because I think that is a very important case for anyone who is an influencer. And generally, as influencers, you are not researching brands to make sure that they are not infringing IP rights. So it is imperative to make sure when working with brands that you at least have something in place for cases like this. It's unfortunate that we have to do that, but I just thought it was important to bring that up. And so for technical file number 6, the next week or the next, when we get to it, we're going to be talking about avoiding popular marks. The goal for you as a brand owner, as a business owner, whatever it is that you do, is to stand out, not to blend in. And so now let's head on over to the IP Streets with Mackenzie. In fact, just before we get over to that, I want you guys to take a look again with some of the online course offerings that we have. The intellectual property referee whistle official trademark course, tongue-tied, has now been made into a instant video download. I will make sure that the link for that is in the description box, but I just want you to take a look at our promotion for the referee whistle official DIY trademark course.
Hello, attorney EJLee here. Trademarks are the first thing that people recognize about your business. However, many startups and entrepreneurs do a limited budget delay the intellectual property registration process, which often leaves them legally vulnerable. Introducing Referee Whistle Official Live Webinar, an exclusive one-day event to get you off the idea sidelines and into the game. Referee Whistle Official Live Webinar is a monthly invitation-only event for entrepreneurs, brand builders, entertainers, authors, and creatives ready to dive into the art of intellectual property protection. Are you ready to register your trademarks but unsure exactly how to do it? Our live one-day session downloads the skills and strategies necessary to identify, protect, and manage your intellectual property so that you develop a worthwhile legacy. You will receive a step-by-step instruction workbook, live instruction from yours truly, and time to ask questions. Sign up for the webinar now at the link or leave your email to receive upcoming webinar dates, discounts, and more.
All right, you guys. So like I said, the Referee Whistle Official DIY Trademark course is now an instant video download, but we have turned the Q&A into a monthly session that we will do. So if you have questions after taking that course, I highly recommend signing up for the monthly Q&A where you can ask questions before filing your trademark application. We just wanted to make this a little more easier for people to access whenever they want to, and then still be able to have access to ask questions. So I will see you guys over in the IP Street segment, and hopefully in a live upcoming Q&A, and you'll have all of that information in the description box. All right, y'all. And so it is time for our segment of what's happening in these IP streets with Mackenzie. Yes, 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 yes. Hello, beautiful.
Hi, how are you?
I'm just peachy. How about yourself?
Doing well, staying healthy. That's the goal nowadays, you know? Well,
Listen,
always, but
always, yes.
even more so now.
Mental health is definitely something we need to focus on. So I'm here for that.
Yes.
Yeah, so let's get to it. What's happening in the IP streets?
Okay, so Dua Lipa is being sued for posting a photo of herself, which I feel like we've spoken about before.
We have.
I want to say it was Nicki Minaj when we had spoken about it. I think it was.
I don't remember whether it was a Nicki Minaj, but we'll just say that it was.
Yes.
I'm not sure.
For posting a photo of herself. And so I think this goes to show, you know, how it can be a common misunderstanding of ownership when it comes to likeness. And then it being the person themselves, you know, being, you know, essentially reprimanded for using social media, their own brand, but it gets turned against them. So what would you advise, you know, younger, maybe not as experienced people who are trying to be on the scene to, what would you advise them to protect themselves from situations like this?
So just to reiterate, when it comes to copyright, particularly for photography, the person that sets up the lighting or the scenes that actually is holding the camera, and I mean a professional, is the one who owns the copyright when it comes to photographs. So anytime we're taking our family photos, photos at school, wedding photos, any of those photos, even though we are the subject of the photos, the photographer is actually the copyright owner. So this is one of those situations. I don't know if it was a picture that was maybe, what's what I'm looking for, authorized. In fact, like it was part of a photo shoot, or whether it was just, you know, paparazzi that takes pictures of them on the streets. I'm going to say that it was probably a paparazzi picture, just because that's what it was said in the article about this particular situation. But I just think a lot of celebrity people are just not familiar or don't understand that just because they are in the photo that they can just post it wherever they want to. They have to get permission. In fact, that just brings me to another thought, that a lot of the Olympic people that have been participating have been posting their, you know, videos of them participating in the various sports, and it has been taken down because they, again, just because you're in the video does not mean you own that material, so where you can post it wherever you want to on your social media platform. So they just have to be mindful that, hey, do I have permission to post this? Just, you know, before you, we're so quick to want to post everything, that we just have to stop for a second and say, okay, wait a minute, let me make sure that I have permission to do that. And that also speaks to, we've been talking about the baby over the last couple of weeks with the stuff that he's been involved in, just kind of just spewing whatever comes into his mouth. And I was saying on Twitter a while back that social media is a blessing and a curse, particularly for celebrities, because we have so much on demand, just instant access to them. So there's not time to vet what they're saying with their PR people. And so they're just sharing their thoughts, and next thing you know, it's a firestorm and they're having to backtrack what they're saying. So I know that sucks for them because, again, at the end of the day, they are human. You know what I mean? So, and then some have no home training to where they don't realize that what they're saying is problematic, and then they'll double down on it. So,
yeah, I really think a lot of celebrities personally should have a media training, even when it comes to interviews. You can get briefed before an interview, but I think when you have moments like paparazzi and things that may be a little more unexpected, when you have some sort of training or coaching, you can better protect yourself and your interests due to having that foresight, essentially, of knowing where everything can go and how big actually things can get.
Exactly. If they didn't take the picture, don't post it. That's
basically
what
if it's a good one, I
mean, then ask somebody. Say, would you mind if I post this picture? I mean, before you just get to posting, because then it'll turn around and you're looking at, again, if the photo is registered with the Copyright Office, you can be hit with fines of up to from $30,000 up to $150,000, including statutory damages, which includes attorney fees. So you just have to be very mindful of what you're posting if you aren't the person who took this photograph. So that is the thing to keep in mind when it comes to copyright and photographs and photography, in particular, where these photographers, that's all they do day in and day out. All right, so what was the next topic?
We were gonna do Rihanna and the Adore Me mark.
All right. Yes. Okay, so I'll just talk off the dome of what I know about this case. Basically, in Rihanna's, I guess, marketing campaigns, they've been using the words adore me as far as, I guess, if someone is looking for a particular brand and they type in adore me or adore us, whatever. What is the name of the brand? I think it's Adore Me.
Adore Me.
Adore Me. So I think what Rihanna's marketing team has been using is adore us, or something along those lines in their marketing. They're not necessarily using the name, but it's just part of their marketing as far as like a clickbait. So if someone types in those words, Rihanna's website will pop up, and that you'll be somewhat, redirected to the Savage Fenty line. Correct. Versus the Adore Me. So I do think it's one of those things where I get their point, but at the same time, you're using words that are synonymous with lingerie. Does that make sense? Mm-hmm. Like adore me or enticing words that make you think
kind of like that romantic,
sexy. Exactly. So when you're using terms like that, when is it a term that people in this industry, competitors in your industry, should be allowed to use? Which is why I keep telling clients, and we've been talking about this as one of the technical fouls, is that we always want to aim to stand out to where your competitors literally do not have a reason to use those terms. Like anytime any type of technology company is trying to use a fruit, if I was Apple, I'm looking like, why you don't need to use no fruit. You don't need to use fruit because you only doing that because you know that we have done it. So I don't want to see no other attorney dressed in no referee uniform. What? I know where you got that from. Don't play with me. That's what I'm saying. So, but when you
especially calling themselves a referee, they can't do
that. Listen, don't do that. Don't do that. I will be looking. I'm known in these streets. I'm known. So don't do that. So that's what I think is leaning there. I don't know how that's going to play out. But yeah, clickbait.
Yeah, like you said, I think it's kind of tough to differentiate from, plain language and just, normal speak when it comes to lingerie or any sort of luxury fragrance or, kind of those items. So I think definitely that's going to be tough.
That's going to be a tough one. So we'll see how that plays out. And what is our next topic?
So we spoke about Kanye West and Walmart. and how Walmart was saying that the Yeezy logo was too close to the Walmart logo. And then we were speaking about how, well, it's Walmart's, shoes, do they have the logo? Because it was a similar pattern. It was a sun pattern, but there was difference in the thickness and kind of the way that it looked.
Right.
So now it looks like Walmart or a third party to Walmart is selling a type of imitation Yeezy shoe.
Wow.
And so I thought it was interesting because of kind of, the background already,
Right.
So I wanted to talk about that. How do you think, and we kind of saw this, not really so much imitation, but with Nike, how people were making spin-offs or, their own creative versions of bigger brands. How does a brand emulate, a different designer without infringing?
Well, that's the thing about
everybody's
fashion.
Inspired by somebody too.
Yeah, absolutely. That's what I was just going to say. When it comes to fashion, as they would say, there's nothing new under the sun. Right. And there's only so much you can protect as it relates to fashion. But what we've seen is, particularly with Nike, and I want to say a lot of the other shoe brands too, they've been filing trade dress trademarks. So if they're known for a certain style, for instance, the Jordan shoe, that's a signature style in some of those shoes, they'll get trade dress protection trademarks for that. So in addition to being able to cover obviously a name, you can do sound, you can do the packaging, you can also do certain shapes. So that's what Nike has done for certain shoes. I'm assuming Yeezy and Adidas, that's Adidas, right, has done the same thing with certain launches of that shoe, where they probably are going to try to go the trade dress route, to where you can say that when people see that shoe, they automatically are associating that as a Yeezy shoe. That is, so obviously if I go to Walmart and buy, and see there, that comes the other part. So one of the things that factors that the USPTO looks at is how sophisticated the market is. Like, are we sophisticated to know that a Yeezy shoe is not in Walmart? Come on, that's an imitation.
But that could go back to the other suit. Remember the other suit was with the logo. We were saying you would know if you were in a Yeezy line versus a Walmart line.
Yes, absolutely. Absolutely. So, I mean, it's one of the factors. It's not, all of the factors. It's just one of the things that the courts will look at. Do I think it's going to work? No. I just think.
You think it could cause confusion in the market?
I don't think it can cause Walmart. No, it's not causing confusion in the market. Oh my God! I thought I was getting Yeezys in Walmart. A shoe that's $600, $700. No.
Hey, look, somebody's gonna claim it. They will.
No. I just think it's gonna be a battle of the Titans because Walmart got all day, and so does Yeezy. So hell, he up in Mercedes-Benz right now, just doing his thing with the Donna album, I guess. So and speaking of the Mr. West, now we're talking about his wife, or soon to be ex-wife anyway, Miss Kardashian.
Yes.
I will have to preface this by saying that from what I've seen as of late with her legal team, they tend to be what I find to be brand due diligence lazy. They will file trademark registrations, whether it's for preliminary or based upon actual use in the marketplace. But for the most part, I believe it's been for preliminary use. And it's like they didn't do a search at all. So like one of the things that we do here at EJLee Law is that we conduct a thorough trademark search. So we're searching across databases if you're depending on if you're going to be a global brand. So we're going to check US records. We're going to check definitely Japan, China, and the UK, to make sure that your mark is available in those markets as well. But we're also going to check different pronunciations, different spellings, all of those different things to make sure that that mark is in fact available. And then if it's not available, we want to see what other classes that it's in, to see if those classes are ones that the likelihood of them coming into the class that client is trying to do is higher. All that to say, it just feels like a search wasn't done in this case. So what are we talking about here with Kim?
So this is a skincare line, if I remember correctly. Right. And the skincare line difference between Kim's brand, the name, just the name itself. The difference is one says by Kim and one does not. Right. And so definitely, I guess the article that I had read was saying, the Kardashians don't have a good reputation when it comes to this.
They
And
don't.
then on top of that, even when their attorneys received the cease and desist order, their response was to the effect of, we're not doing anything, illegal by having this. It kind of seemed a little, like you said, just a lack of due diligence. And this is a Black-owned brand, which we've seen, an issue when it comes to just smaller brands in general, that this article said steamrolls or get steamrolled by the Kardashians.
I love a good title. It gets the people going. It's catchy.
Yeah.
One thing I will say about this, shout out to Eric Pelton, who is a well-known trademark lawyer in my space. He's sort of like a celebrity to some. So, but he is actually the attorney for the person that sent the cease and desist letter for this, in this situation. And basically, so of course I had to check the records. I thought they had already received protection for this brand, but it looks like they actually just filed in March of this year. But the brand has been in use, according to this, the records, since August of 2018.
Kim's brand or the smaller brand?
The smaller brand has been in business since 2018. So obviously with Kim, it's just another thing she's adding to the repertoire. And again, most of the time from what I've seen with Kim's legal team is that they file preliminary applications, which is basically what we call intent to use, where they're trying to get pre-approval ahead of time. And then after they get the pre-approval, they have 6 months from that date to actually launch in the marketplace. And then they will go back into the system and file a statement of use showing how they're using that mark. So again, it just looks like there was no research done whatsoever, because I mean, I literally just put in SKKN and that skin with the plus sign popped up first. So you can't argue and say you didn't see it. By Kim. Like you didn't see it? Come on. They just didn't do a search. Kim just said, hey, I want to do skin by Kim and skin. And like, okay, cool. And just stop. There was no search done. I'm sorry. I just don't feel like there was any search done.
I just feel like it also feels a little confusing, because isn't she trying to become a legal professional?
Oh, Lord. I don't even want to touch that.
Okay.
Because yeah, I'm not even gonna touch that. Okay. Well, she's probably not going to be an IP lawyer, okay? Because
it's still a fact of due diligence that goes in every field.
You are 1,000% correct. But I do think a lot of times lawyers, who are general practice, or a master of everything is a master of nothing, in other words. So you stay over there in your criminal law and getting these exonerations. Don't come over here into these IP streets, because we're gonna smack your butt.
Refer it
out, ma'am. But I wonder if it's the law firm that's training her.
Well, like you said, we're not going to speak about that.
We're not going to speak
about the skincare line. And what would you give smaller businesses advice as far as, I just feel like it's almost an unfair advantage, that Rihanna and the Savage Fenty, for that smaller brand, and the Adore. Granted, obviously, Adore is a different type of issue, but the fact that it's a smaller business going after Rihanna, or a smaller business going after Kim, how would you advise? I mean, just lawyer up and be prepared, or make sure you're doing searches routinely. What would you suggest?
Well, one good thing for this brand is that they have Eric Pelton on their side, because by him having the name that he has, the news picked it up like that. So, I mean, in a sense, this has probably helped business pick up, because they're a smaller brand. So I guess use the 15 minutes of fame in best way you can. On top of, again, this also shows that had they waited any longer, that Kim would have been able to file this, and we might be looking at a completely different situation in terms of the fight for the trademark. However, we always talk about common law rights as well. So this brand obviously could have argued that they were the senior user since they have been around since 2018, but they literally just filed in March. So imagine the fiasco if they were trying to come behind Kim filing. So all this to say that don't think that just because your brand is unknown now that it's going to be unknown later. Something like this can happen, and boom, before you know it, your brand is blowing up. Again, I love using the example, unfortunately, from when Kobe died. Girl Dad became like this really popular slogan, and so there was a lady out of Utah who just happened to have it for clothing. I can only imagine how many sales she made behind that. Just because she had the registration. Now, initially, when she had it, she probably didn't think anything of it, didn't think it was going to become what it became. But that's you're always looking for that moment. Don't think that just because your brand is small that it's not worth protecting, because it'll be that one time. And hey, if somebody pays me enough money to rebrand, you can have this name, but you have nothing. You have nothing if you don't have the trademark registration, that intangible business asset that can take you from way down here as a brand to up here, simply because you took the time to take care of that. So just don't leave it up to chance.
And that's that on that.
That's that on that. All right. So that's another episode of Blow the Whistle with EJLee Law. And Mackenzie, thank you for joining us in these IP streets. And we will catch you guys on the next episode.
See you later.
Bye, y'all.